in the matter of petitioner Charles Paul Nurswick versus respondent Lindsay Ann Dineski. Ms. Dineski, please state your name for the record.
Lindsay Dineski.
Please raise your right hand. You solemnly swear to affirm any testimony you provide to the court today will be the truth and nothing.
Well, that's not true. Anyway, hey guys, welcome back to the channel. Today, we're diving into the next chapter of the Lindsay Dineski saga. Part 4 took an unexpected turn because, surprise surprise, Lindsay was recently arrested for resisting arrest after refusing to step out of her vehicle when ordered by an officer. Not exactly a bright move, especially when you already have an active warrant hanging over your head. I've already submitted a request for the body cam footage, and while we wait for that to get approved, let's shift gears and watch another sovereign citizen Karen doing what she does best, making a complete fool of herself in court. Let's get into it.
December 4th, 2003.
There was no proper service on that. I was never given any service on that warrant, so it's invalid.
So the warrant issued because you failed to appear
For a court that I never received any service on.
for the show cause hearing. I do see that proof of service.
I was in another state, so there's no way I received any proof of service, and you guys had my email and my phone number, and nobody ever contacted me, so this needs to be thrown out immediately.
So that's not how the court.
Yes, the law says. The law says if I do not have proper service, it's an invalid warrant.
That's technically true, but in Lindsay's case, it doesn't even matter. Why? Because she moved out and never bothered to update the court with her new address. According to MCR 2.107, service is considered valid when sent to the last known address listed in court filings. In plain English, if you move, whether voluntarily or because you got evicted for being a delusional sovereign citizen, you still have to tell the court where you live. Otherwise, they can legally serve you at your old address, even if you're long gone. So, while the court steps out to confirm that the service was done correctly, just watch how Lindsay doesn't miss a single beat when the judge comes back.
Been able to present any evidence.
Be quiet.
This is my hearing, and I'm allowed to speak at my own hearing.
I have to let you know I'm arraigning you.
You're reading it on an invalid warrant. This needs to be dropped immediately. Is this an Article 1 court or an Article 3 court? Because if this is not an Article 3 court, you have no right to adjudicate anything to do with my liberty interests. And my children are my liberty interests, and they are my offspring, and this man attacked me, so this entire PPO is based on fraud and is void. So that not only can you not arraign me, but you need to overturn the PPO immediately.
So, Ms. Dineski, you were served on October 23rd, 2023. There was a show cause hearing for a violation of the PPO that occurred on December 4th, 2023. Just for the record, I have muted Ms. Dineski because she refused to be quiet.
You're not allowed to mute me at my hearing. Is this an Article 3 court or an Article 1 court, ma'am? You have to answer me. Are you an Article 1 judge? Because if you are, President Trump said that you are not allowed to hear anything to do with my liberty interests in his executive order that he recently put out.
All right.
Are you Article?
Is that you stopped Mr. Nurswick's mail? You were interfering with his mail, Ms. Nurswick, and wasn't able to receive his mail.
If you do not have a constitutional oath, then you have to recuse yourself immediately and let me have an Article 3 judge, because this has to do with my constitutional rights. And Article 1 judges.
So the court is in receipt of a customer information form that appears.
You do not consent to this PPO, and you must prove and show your oath.
USPS at an address of 18337 Ewell Road, Belleville, Michigan.
I was not living there. I had been evicted from there previously in June, so there was no proper service.
The petitioner filed a motion complaining that you, Ms. Dineski, stopped his mail.
I didn't stop anybody's mail. He came and stole my mail and signed for a certified letter that he sent me, so I didn't receive it. And you guys won't let me show evidence. This has been going on for over a year, and I've never once been able to show evidence, and I've demanded a trial multiple times, and you've denied me a trial. So you're going to be going to prison under USC 18, 241 and 242, and I'm going to be asking for the death penalty.
Ah, that's adorable. Lindsay's out here channeling her inner Oprah. You get the death penalty. You get the death penalty. Everyone gets the death penalty. She's even thrown that threat my way a few times, and honestly, at this point, I think we should all wear it like a badge of honor. Now, in this next part, the court steps away and leaves her alone on the call, and that's when things get really interesting, because Lindsay starts having a full-blown conversation with herself.
This is also a bill of payment penalties, which has been outlawed by the Constitution, Article 1, Section 9, Clause 3. You are using an unlawful PPO to withhold me from my offspring, which qualifies as kidnapping and hostage taking and treason and torture. This matter is void ab initio from the beginning because it's based on fraud, and fraud vitiates everything. Marbury versus Madison, anything repugnant to the Constitution is void. This is a violation of my free speech. This is a violation of my right to petition the government for redress of grievances. It's a violation of my Second Amendment because you said I couldn't have a weapon or bear arms.
Ms. Danelski, I'm gonna put you in the breakout room with Ms.
This is a violation of my Sixth Amendment. This is a violation of my Sixth Amendment. This is a violation of my Seventh Amendment. This is a violation of my Eighth Amendment right, my inalienable Eighth Amendment right. This is a violation of my Ninth and Tenth Amendment rights. You are violating all of my rights, and I have not ever been allowed to be heard. Due process allows me the right to be heard, and this has been ongoing since 2023, and I have never had the right to be heard. And I've had my babies unlawfully held from me based on fraud, which I never got to present evidence.
Lindsay just does not stop talking, ever. The judge steps out for a bit and comes back only to postpone the hearing a few hours while they wait for a prosecutor. Now, under normal circumstances, an arraignment like this could easily move forward without one. But Lindsay? Well, let's just say she adds a special kind of chaos to the mix.
I want to reconvene at 2 o'clock.
I'm demanding a quo warranto.
All right.
And
Deputy, did you hear me? Officer?
Your Honor, I do have a 2 o'clock. Did you want me to come back? I have a 2 o'clock in judgment.
I don't need an attorney. I don't consent to an attorney.
Yeah, I can't. I don't have a prosecutor. I need you to come back. What about 2:30?
I want to say something. You guys are.
Williams,
Your Honor, I'm talking to
5 days.
I have no prosecutor.
I was not even notified of this court. I was not even given notice of this court date, and I've been here.
So let's say 1:45. I don't have a prosecutor.
You need to be quiet. This is my hearing.
Can we do 1:45, officer?
Yeah, 1:45.
Okay,
All right, we'll see y'all back at 1:45.
Okay, thank you, Your Honor.
I do have one question.
Go ahead, officer.
Just for staffing purposes, can you give a time, because that's right around shift change, do you think that hearing would be done by 2:30, or are
I'm waiting on the prosecutor. I can't.
Well, it has
The
to
record is
Your Honor,
going now.
I have a 2 o'clock.
I can't call it. So
Prosecutor, I'm asking for this to be dropped.
yeah, 1:45 is the time that I have.
Why won't you answer any of my questions?
Your Honor, I'll see you at 1:45. Thank
Sounds
you.
good.
Well, maybe stop asking pointless questions, then. A few hours later, the prosecutor finally arrives, and the hearing picks back up, though something tells me it's not about to get any less chaotic.
Prosecutor's office, but
I kind of thought so. I did start, but for this particular one,
Yeah, this one, I think.
considering the fact that,
yeah,
this is, we needed you here. That's why I started off and I was like, oh no,
Leslie, as far as the allegations go, I do believe that this is a bench-borne arraignment.
hold on. Yep, it is. Let me start to call the case. All right, CJC, are you there? I want to call the case, but I want to hear from you.
Yes.
All right. All right, thank you. Let me call the case.
Recording in
This is
progress.
case number 23-104850-PP in the matter of Charles Nurswick versus Lindsay Ann Dineski. Mr. Tudge, if I could get your appearance from the prosecutor's office.
Good afternoon, Your Honor. Gregory Tudge, P85961 for the people.
All right, Ms. Fort Williams, your appearance, please.
Good afternoon, Your Honor. Gail Fort Williams, P35963, House Counsel on behalf of Mr.
All right, Ms. Fort Williams, you had an opportunity to speak with Ms. Dineski in the breakout room.
Why is there still an attorney on my case when I said I don't want one?
I attempted to speak with her, Your Honor.
I do not want or need an attorney.
All right, Ms. Fort Williams, I just want you to stand by at this time, if you can do that.
And I'm entitled to relief from judgment under Michigan Court Rule 2.612 because I was not personally notified of this matter. And so it needs to be dismissed immediately.
Ms. Dineski, you were arrested for a warranted issue because of your failure to appear.
A failure to appear on something I was not personally notified on. So under Court Rule 2.6123, not personally notified, I am entitled to relief from this proceeding and action.
And let me hear from Mr. Tudge. Go ahead, Mr. Tudge.
Your Honor, it does appear that 2.512, I believe, was the citation, which 2.516.
I'm sorry, 2.612.
Chapter 2 of the Michigan Court Rules governs the civil procedures. This being a quasi-criminal matter,
This is a civil procedure because it's family court.
Hold on, Ms. Dineski, let Mr. Tudge speak.
It's not quasi-criminal, this is civil.
All right.
So that's a twisting. This is a family court matter.
Ms. Dineski, please let Mr. Tudge speak first, please. Go ahead, Mr. Tudge.
I thought this was my hearing. I should be the one speaking.
Mr. Tudge is from the prosecutor's office.
He doesn't need to be on this case because it's civil. Prosecution doesn't happen on civil.
It actually does matter when there's a criminal element involved, like ignoring a court-ordered protective order. That kind of move can easily turn a simple civil case into a full-blown criminal one.
MCR 2.612 does appear to be governing civil proceedings. This matter being a quasi-criminal proceeding does and is controlled by the court rules which address misdemeanor offenses unless otherwise stated in Chapter 3 under special proceeding. I do believe that the cited rule is inapplicable for this proceeding.
You may proceed.
I'm sorry, I didn't hear him. Did he say applicable or inapplicable?
It is applicable, Ms.
Oh, okay.
Okay, go ahead.
Your Honor, I must correct the court. The argument is not applicable, inapplicable.
Oh, he said not applicable.
Why would it be inapplicable?
He's saying the court rule your side, his position, and I agree with him. Let me just say that for the record, that the court rule your side, it governs civil procedure. It doesn't govern under quasi-criminal matters.
This is not a criminal matter. This is a civil matter. It's a domestic matter. How is that criminal?
Ms. Dineski.
And in criminal procedure, it's the same thing. These also, the criminal code also.
Dineski,
the reason why I looked up the.
I'll give you an opportunity to speak, but I need to hear from Mr. Tudge first.
But it's my hearing. I should be heard first.
No.
This is my hearing. I'm the one who's supposed to be heard, not the prosecutor.
But they're being heard because you're violated a PPO.
I didn't violate anything. I was not notified.
Sorry, the allegation that you violated a PPO.
Okay, well then I have a right to say I was not notified.
I'm going to give you that opportunity, but you have to. The allegation is that you violated a PPO. You have to let the prosecutor's office, the representative of the attorney from the prosecutor's office, speak. Go ahead, Mr. Tudge.
Your Honor, I don't believe I have anything further as to the argument as it relates. I would ask that the arraignment for the bench warrant continue, and I would also ask that the court inform the respondent of the standards for which respondent will be held if proceeding pro se, and I believe it would be appropriate.
I'm proceeding sui juris in
Well,
persona.
I am going to ask Ms. Fort Williams to operate as
No, I don't want an attorney. I do not
standby
consent to an
attorney.
attorney.
Ms. Janeski, I have acknowledged the fact that you are not wanting an attorney.
No, I refuse it. It's not that I don't want one.
I have Ms.
refuse
Fort Williams to stand by. She's just going to stand by.
Even though I
What else would
appreciate
you like to say, Mr. Tudge?
I believe it may be of benefit for the court to voir dire or Attorney Williams to voir dire respondent as to a right to have counsel and whether respondent knowingly, intelligently, and voluntarily waives the right to counsel.
All right, Ms. Dineski, you understand? Go ahead, Ms. Fort Williams.
Your Honor, I just wanted to say, Ms. Dineski was speaking about being served with the violation, and she's indicating that she was not served. She may have been quoting the incorrect court rule. I don't know. I don't have the court rules in front of me. It doesn't matter, though. Either way, of course, anybody in court has to be served with the appropriate papers. What she is indicating is that she was not served. And I indicated to her, but I don't think she was listening to me because she was talking and I couldn't talk. I indicated to her that this is an arraignment and that she will have the opportunity to address service or lack thereof, if that is the case, when a trial is set or whatever is set.
No, according to versus McVicker, I can challenge us at any time.
Your Honor, Ms. Dineski, you have to be quiet. For purposes of what she was indicating, Your Honor, it is true that everyone has to be served. I don't know about that court rule, and it doesn't matter whether she's quoting all these rules. It doesn't matter. She's indicating she wasn't served. That's all. Thank you.
Thank you. But the thing is that it doesn't matter if this
Hold
is
on, Miss. Procedurally, there are things we have to do.
What are you even saying right now? Of course you'd want things handled procedurally, especially if you honestly believe your rights are being violated. You've literally cited multiple court rules during this hearing, which means you acknowledge and agree with the Michigan court rules. So, whether you're pro-SE or not, you're still trying to move procedurally. Proceed.
Your Honor, it's indicated, I believe in the court record, a proof of service has been submitted. If there are further questions as it relates to service, and ultimately it may be, however, I leave this to either respondent or if respondent wishes for an attorney, respondent's attorney to address that if there is a request or a motion to have the court issue a summary judgment as to the alleged violation, the burden of proof would be on respondents to do so.
All right.
No, it would not be. The burden of proof is on the one who would process the service. I was out of state when this hearing was set up.
I do show that a proof of service was filed for notice of hearing for the show cause that took place on December 4th, 2024 by the attorney that was representing Mr. Nurswick.
So where did he serve it to? Because I wasn't even in the state of Michigan. I was living out of state at the time, and you guys they have my email, and they never even emailed me. They have my phone number, so I wasn't notified by phone, email, or mail. So if they served it to the Elwha house, Chuck is the one who signed it, which is fraud. He has been defrauding the court since the beginning of this.
There is a proof of service in the file that was filed on November 8th, 2023, that a notice of hearing for the show cause on December 4th went out. Have you, Ms. Fort Williams, talked to your client? How would you like to enter a plea on her behalf? What plea?
No, I do. She doesn't need to enter a plea on my behalf. I said I don't want an attorney. Why do you keep going to her? I want to speak for myself.
All right, let me say this. Ms. Dineski, you've been advised of your right to have counsel. Is that correct?
No, I have a right to assistance of counsel.
All right.
Okay.
Do you want assistance of counsel, Ms. Dineski?
She can assist. She already told me her opinion, so I appreciate that, and I'm competent to speak for myself now, but I do appreciate her very much.
So you ask for the assistance attorney, Ms. Fort Williams,
No, I didn't ask for it. She gave it to me and I accepted her opinion, but I don't, the law does not agree that I can't ask for this to be dismissed in an arraignment because Lufkin v. McVicker
So
says
your
that.
request
Because courts don't just toss out cases every time a stubborn Karen throws a tantrum and demands it. That's not how the legal system works. That's why.
It's my turn to speak. When do I get to speak?
hold on.
Your Honor, I asked that a plea of not guilty be entered, and I'm asking that she be given personal bond. She is a resident of Detroit, Your Honor, and she's been incarcerated since the 13th. And I'm asking that she be released on her personal recognizance. Thank you.
Thank you. Because I'm living locally. If I knew there was a court hearing, I would have been
Mr.
there.
Judge, if I can hear from you, please, as it relates to bond.
Your Honor, as it relates to bond, I did have the opportunity to speak with the petitioner prior to today's hearing. It's my understanding that there has been numerous instances of contact with the contact from respondents beginning on or around December of 2022, which I understand predates the personal protection order, this being when unwanted contact is alleged to have began, and the last instance of unwanted contact on or around February of 2025, just 5 weeks ago is what I've been informed of. I would, given both the allegations of contact and the information of continuous contact, as well as respondents' failure to appear for the prior proceeding, I believe was set for a bench trial, it does appear that there may be a concern of respondent attending future court hearings. And as such, I would argue that a GPS tether would be appropriate for both the security of the public and petitioner, as well as securing the respondent's future attendance at court proceeding.
All right.
Do I get a chance to speak on my own behalf?
I'm going to give you that chance. Ms. Dineski, are you incarcerated for any other matter?
Yeah, I'm incarcerated, falsely arrested, because I asked to talk to a supervisor when I was pulled over in River Rouge, and they beat me up and pulled me out of my U-Haul and beat me up and arrested me and put me in a dungeon.
You've been throwing around case law like you actually understand it, but I guess when you graduated from the Williams Fried Chicken School of Law, they skipped the part about Pennsylvania v. Mims, the one that clearly says if a police officer gives you a lawful order to step out of your vehicle, you don't get to say no.
Since the beginning, ma'am, I have been telling you that this needs to be dismissed. I have not had my chance to put any evidence in. You unlawfully dismissed the PPO that I had against Charles Nerswick, and then you went ahead and reissued a PPO right after you dismissed the one that I had against him, which is unlawful. You dismissed the original PPO against Charles Nerswick that I had after he admitted to trying to run me over. I'm talking now. It's my turn to talk. Let me talk.
What is your bond on the felony case? You're charged with a felony right now?
I am, unlawfully. And I'm already getting a tether, so it's a moot point.
So what is your bond on that case?
$10,000.
Is that
And I'm going to be asking for a bond reduction.
all right, so
I'm not even going to be getting out anytime soon anyways. But my point is that this needs to be dropped because I've never been able to show evidence. And on my
at a $10,000 cash surety with tether?
Yeah, with a 1% or 10, whatever, I have to pay $1,000 to get out.
Okay, so it's 10,000, 10%?
I guess, yeah.
With tether.
With a tether.
Go ahead.
The thing is, but my point is, I would like to speak on my own behalf about this PPO because you dismissed. You need to recuse yourself because you have violated my rights from the beginning of this case. You did not let me show evidence in my original PPO case, and you dismissed the PPO when I never had a chance to have evidence. And that man Chuck, who kidnapped my babies from me, who has never even been found to be the biological father of these children. Lawfully. The thing is that you dismissed. You said I could have a chance to talk. Please let me state my case.
Mr. Tudge would like to speak at this time. Go ahead.
It's my turn. You said I could have it, and you keep letting them speak, and you will not let me speak.
Mr. Tish, what
It's
is,
my turn to speak, so I'm gonna say that this needs to be dismissed because you did not let me show evidence, and then you
your
dismissed the PPO against a dangerous man who admitted to trying to run me over with his vehicle on his documents, and then you dismissed it and turned around and gave him a PPO against me when I was asking him to let me see Haley, who I raised for 5 years, and to get diapers for our babies, who he had abandoned for over a month, and then he kidnapped, and then you facilitated that kidnapping. So you must recuse yourself from this case because you have violated my rights numerous times, and I've asked for a quo warranto. I have asked you to show me your Article 3 oath, and you have refused. And if you're an Article,
to dismiss the matter is denied. I'll hear
why?
from Mr. Tish.
Why? What lawful reason do you have to continue this?
Mr. Tish, what would you like?
What law, Judge, you need to answer me. What lawful reason do you have to continue this?
1 second. Go ahead, Mr. Tish.
Thank you, Your Honor. As it relates to other bonds, I did have the opportunity to search. I believe the case in reference would be a 22nd District Court case. Presently, my records are not showing any arraignment having taken place. I did search the Michigan court case search system and did not locate any present bond or active case involving respondents. Now, I do see that there had been issued charges for an assaulting, resisting, or obstructing a police officer, which would be placed at the 22nd District Court. Also,
those were dropped. They told me that they were dropped and they let me go because they wrongfully arrested me based on a false allegation. So that I have to deal with.
Trying to get information from Mr. Tish. Let him finish.
No, I know, but I'm letting you know what happened in that situation. Somebody had me arrested, and then they found out that the guy gave them false information, and they originally were going to charge me with that, and then they let me go that night, and they said they were dropping the charges. So for some reason, it just never got taken out of the lien system, and I didn't know that. So I do have to deal with it, but that's not my fault. That's the 22nd District's fault.
Okay, let me hear from Mr. Tish. He's reading from the system so that I know what it is that he sees that's in the system. And so you know what's in the system. Go ahead.
I do appreciate that. Thank you.
I would also note a case out of Washtenaw County that does appear to have also been charged with 2 offenses, misdemeanor disturbing the peace and attempt misdemeanor of assaulting, resisting, or obstructing a police officer.
That's the one that got dropped.
I'm not in possession of any adjudication on the matter. What I would interpret as respondent's motion that Your Honor recuse yourself from this matter. I don't believe the requirements for recusal are met. There being no argued evidence of impropriety.
Well, it's not really up to you to decide. You weren't there on the original case when she violated my rights and denied me a trial in the original PPO and did not let me put my evidence in. So because you violated my rights in that original PPO, you must recuse yourself. And I am demanding a new judge. I'm demanding a higher judge. I'm demanding the chief judge.
All right, Mr.
I have a right to that.
Mr. Tish.
Like maybe outside of this, you'd be a cool lady, but you violated my rights in this court, and so I have a right to a judge who has not violated my rights.
Are you asking that Ms. Dineski just be placed on tether?
Yes, Your Honor.
And I object to that. I should not have to be on a tether. I've not broken any laws. I've not harmed anybody. I'm the only one who has been harmed by this. This unlawful PPO has kept me from seeing my biological offspring for 2 years. This unlawful PPO has kept me from my babies for 2 years. They took a good mother. I was nursing my babies. I was with my babies every single day, and you guys helped a man who tried to kill me to cover up his crimes, kidnap those babies. You should be ashamed of yourself. And so because you helped kidnap my babies, I deserve a different judge. I am entitled to a different judge. You have shown misbehavior and impropriety under the canon laws of the judge's rules.
Ms. Dineski, I'm going to enter a not guilty plea on your behalf. You'll be given.
I don't consent to plea. There should not be a plea. This should be dropped.
I'm gonna give you a 10,000 personal bond. You can be released on GPS tether.